Okay, so hello and welcome everyone to this For IP Council webinar. Today it's about IP and startups, what, why, how. I'm Marta Sierra, I'm Head of Marketing and Communications at For IP Council, and I will be your host today. So for those of you who haven't heard about For IP Council, I'm going to give you just a very brief introduction of what we do. So we are a non-for-profit European organization that creates empirical research on the link between innovation and intellectual property. To do so, we count with the collaboration of IP experts, academics, other European institutions, and we always make sure to choose relevant topics and current topics for the audience. So if you go to our website, foripcouncil.eu, you will be able to find all our papers under research. You will see that we also have a case law summary section, and we also have all the previous webinars recordings available on our website. So if this is the first time that you join us and you would like to check out our previous webinars, you can access to all of the recordings from there. You will also see that we have a podcast called IP Stories. And here we interview entrepreneurs, CEOs, researchers, IP disseminators, and lots of great guests with very interesting IP stories. So if you have a startup, I think this is also a great place to go and get all this knowledge from very, very interesting people. And also, we have a section for non-IP experts, okay? All the content there is tailored to non-IP experts. It's called For SMEs. You will find infographics, a lot of visual content. And if you are getting started on IP rights and you need to start from the basics, this is a great place to start. We also have a new area on our website that it's called IoT and Cellular Standards Made Simple. Here we have created an area to express the impact of cellular standards in technology across so many different sectors. So you will find videos, loads of different examples, and you will see just how much effect it has had across so many different areas. And finally, if you want to make sure that you don't miss out on our future content and our upcoming webinars, you can follow us on X, LinkedIn, YouTube, Instagram. You can also find our podcast, IP Stories, on all the main podcast platforms. And you can also subscribe to our newsletter. You will find the link to subscribe on our website. So without further delay, it's my pleasure to introduce our speaker today. He's Dr. Professor Martin Bader. I'm going to give you just a few details about his biography, but you will be able to find his full biography on our website as well. So Dr. Bader is a Swiss and European patent attorney and representative before the Unified Patent Court. He is the co-founder and managing director of BGW AG, specializing in intellectual property management. He serves as a full professor of technology management at the University of Applied Sciences in Ingolstadt, adjunct professor at McGill University in Montreal, and lecturer at the University of St. Gallen. Now, before I hand the floor to Martin, I would like to give one final remark to our audience. You will find the Q&A tool at the bottom of your screen. You can submit your questions at any point from now. We will take the questions at the end of Martin's presentation when the Q&A starts in the second half of the webinar, but you don't have to wait until then. You can already submit them. Well, thank you very much. And Martin, the floor is all yours.
Yeah, thank you, Marta. Welcome to this session also from my side. I'm straight away kicking off based on the title and invitation that For IP Council asked me to refer to today with a question, why? I quite like to start with why. So why do we talk about intellectual property? Why would that matter? I guess everybody of you has a certain perspective to you. One case I would like to refer to demonstrate this is Spotify, the music streaming service. I guess you know it. And what you might know or not know, that this company had to fulfill several aspects to become successful, and intellectual property played an important role here. For example, the patent I looked up for you from Spotify is one that covers their technology for a seamless peer-to-peer streaming of media content. And at that time, when they started, it wasn't so obvious that you could stream music seamless via the internet. You would have maybe some little disruptions. So they thought, okay, how can we get this experience which consumers realize easily when they press on the streaming button, the delay time until the music starts. And they were working on this because they thought this is an important aspect of their service and the experience that customers would have or users would have with this. So they said it's important to develop the technology, and they also realized it's important to get a protection from an IP side on that. Yeah, because if people would like to, if competitors would like to do the same, they might start exactly there. What you probably also know, of course, to stream copyrighted content of others, they also realize they have to find a solution to that, although at least due to the saying in the beginning, the rebels were not fully on that page, but in the end, to become successful, they were. And you also see that it's a known business model. We call it in academia, but also in business, we call it the freemium business model. So the base product or service is for free. So it reduces the barrier to enter the service. But if you want better services or extended services, you will have to sign in and pay a fee for that. And finally, of course, the brand on the market which they established. And for those who want to get a bit of feeling, Hollywood style feeling on it, some of you might know there is a movie that is available or was available on Netflix called The Playlist. So I was interested in it. I can only recommend maybe checking in there and having a look at this nice movie. And of course, it's a movie, but it demonstrates pretty well how much intellectual property a startup like Spotify had and how they dealt with it and what problems also they had to solve. Second aspect I want to show to you where it wasn't such a success is Napster. Some of you might remember this too. They also started as a actually music sharing platform, which was very fancy at the time and used between, let's say, also other rebellions. But there, a typical thing happened, and I will refer to that later on once more. You see, in 1999, they started the platform. And as soon as it became known and sort of successful, already 2 years later, they were not only discovered and sued by copyright owners or representatives, but it went so fast that they even had to file for bankruptcy. And this is typically when you are working in a startup. I don't know how many of you are currently dealing in a startup. So if you're staying, let's say, unsuccessful, then it might not matter a lot. But at the latest, when you become successful in terms of the business or the endeavor you were following, then you have to realize that there might be competitors who try to do the same or who envy your success, or like in this case, if you're behaving like doubtfully, legal misconduct or just illegal, then people will come up to you and will realize, okay, and tell you that they might have a different opinion about your business and what's okay and not, and might come up to you and might even, like in this case, try to shut you down. And what I also think it's interesting with Napster, because the company, I mean, the name and the brand sort of still exists today. This was the main leftovers that even survived the proceedings, the bankruptcy proceedings, and was sort of reused later on. Although also this is a bit complicated story, but as you can see, if you compare Spotify to Napster, they sort of started in the same area and ended up so differently because one dealt with it properly in the end and the other didn't manage to. So you can see it makes a lot of a big difference. Another example I bring here up to you, is what's so fancy about IP? One is let's look on the risk we run here. And an example I bring here to you, a little case, some of you might know it anyways. It's the Blackberry. That was how the device was called. The company behind it was called Research in Motion, RIM. And you can see if you look at the numbers from the years, they introduced the first successful version in '99, the first sort of consumer-based version in the market. And already 2 years later, bang, they were successful. The first voices came up saying, well, is that okay? And do we like that you're doing business here? And they got actually sued or caught in a patent infringement case, couple of cases actually from NTP. What's maybe special here that some would call NTP a patent assertion company, so that owns and buys and owns patents to enforce them and make a business case out of a legal case. And although you might say, well, this is not really a nice business practice, it exists, and it still exists, a bit differently than at that time today. As you can see, Blackberry or Research in Motion, the company behind it, finally managed to deal with that case. And you see, they were fighting like 5 years. And one reason why they could do this, because of course they had a lot of more cash than Napster had at their time. So they finally settled. And for those who know a bit more about it, it wasn't an easy settlement. It was really like a couple of days before they were scaring an injunction that would have shut them down. And even more ironically, very, very short time after the settlement, those patents, those enforced patents were revoked in the end. So if they had behaved differently, either much earlier, settled much earlier, or had recognized that there is an IP issue, they could have settled much earlier at a lower price. Or if, let's say, if the case would have run differently in this example, the patents were even considered as void, but after the settlement, so the money was gone. So this is a very special case, and it still accounts to one of the biggest disputes in history. And even given that the patents in the end were void, it even put up some questions on the whole patent system and how it is. But as a startup, we don't spend time whining about the patent system. We should just, respect that it is there. And second, deal with it in a way that that it's good for us. And one is, so to summarize this aspect, take care of the risks that are business critical. But it's not only risk, and that's a nice part for us at startups. There's a second aspect, which we call, oh, sorry, I was clicking too fast, which are the opportunities. And a case that I brought here to you is Google Earth. The funny thing is, for both cases, for the Blackberry and also for this one, there are again two other Hollywood-style movies. The one with Blackberry is actually called Blackberry and was released last year. And the other one here, Google Earth, it's called The $1 Billion Code, and was also on Netflix, and I think it still is, depending on the region you are in. And with the Google Earth example, I'm coming from Germany, so could almost say it's a German case in terms of failure in commercializing an interesting technology. And it was a concept where you could, I guess most of you know Google Earth, where you could use a globe as a device globe to show where you wanted to see something of the Earth, and maps from the satellite map. and then the system would transfer it on these satellite screen saved satellite pictures, and would show it and display it on a screen. So you could argue this was the first version of a Google style demonstration visualizing satellite maps, at that time very new, and it still needed a lot of computing power. That's why it was so special, and it was new that you would have the computing power at all to sort of project vector related satellite pictures. And they basically ended up in not getting the opportunities out of this IP, not commercializing it in a way that like in the end, actually Google did. Although, of course, the Google business model, as they don't have only Google Earth, but many other things, including the advertising business, internet-based advertising, was, of course, a different business model. But here you could argue, okay, although they had a patent, they didn't manage to build a case out of it and using the IP. And even worse, they even didn't manage, even up to the end, not to commercialize the patent based on Google having already sort of a working version in place. So they basically missed the opportunity to commercialize the technology, one end, and second aspect, commercialize the patent. And yeah, you can watch the movie. And what's also interesting, there are some interviews with the inventors or the originators of that system, which might also be very interesting. It's a bit like behind the scenes inside how this went. And I think it demonstrates very well that inventing something is one thing, and innovating, sort of commercializing, making it a commercial success is a second aspect. And as a startup and or as an SME, we want basically to do both, at least the innovation part. Okay, go on. Oh, yeah, and so to summarize this aspect, what's typical for SMEs and also for startups, typical issues are first of all a lack of awareness. So if we watch away, if we don't admit that it exists, of course, how would we be able to handle it in a way that is good for us, or it is optimal for us? Yeah. Then second, if we don't have the awareness, we typically don't have any knowledge about it, or not enough to know. You see, if you run in the mountains, have no clue of dangers in the mountains or avalanches and these kind of things, then of course you don't even might realize that you're in a danger, nor you might be able to really climb the mountains because you can't do it. Yeah, that's sort of the opportunity side. And one aspect I want to touch today too is, yeah, how can you build up then a right way to deal with IP, a right strategy, getting the right operations in place and implementing an IP strategy that helps your business. Then a typical argument is we don't have enough resources, which is true. But if from that point of view, as a startup, I have never enough resources in place. So it's a bit like, okay, we are juggling anyways, and my claim today is there might be one juggling ball more in the air than you had maybe in the past. Or if it's in the air, then make it part of your juggling ambitions and juggling performance, and include it in what you're doing. So shall we already go into questions, Marta? I'm just asking this, or shall we continue here?
As you prefer, Martin. Is there any other case that you wanted to show, or this is the end of the presentation?
No, I still continue. I still have some aspects.
I think let's continue a little bit more. Questions are already coming in, but I'm going to give a reminder to our audience. You can already submit your questions, and we will take them in a bit.
Okay, cool. Okay, then I continue. So to summarize let's say this first part, you can see, and this might be also new for some of you, it's a risk perspective and it's an opportunity perspective. The risk perspective is, okay, what risk do we run into, what might happen, and so on. So this is like the ugly almost boring part, you could argue. But there's also the second aspect of opportunities that you can rise and tackle. And in business, we typically talk of missed opportunities. So you can also lose edge by not taking those opportunities that you might have, by missing them out, or just ignoring them. And when we deal with IP, we typically want to do both. So we want to mitigate the risks, and we want to leverage the opportunities. So it's always those two things. So I will show some examples to that too. So how can we maybe mitigate risk? Mitigate risk doesn't mean that we can might not be able to fully avoid those risks, but it's good to know what kind of risk might there be, and what is the probability or the size or the sort of the worst case or this case scenario with that risk. And also what would be adequate measurements, first of all, to understand the risks, and then to deal with those risks, meaning neutralizing in a way that effort and benefit are in the right way, and that talking from a legal perspective, that you are maybe that you remain in the legal side, and that you are doing your duties, maybe even that you have to do in your legal system you are in. And one aspect that I want to show here is already the contract. So imagine you're licensing in something, or you're doing, if you're a startup, a spin-off from a university, and you have a very, very complex IP contract with a lot of stuff in it. And imagine an investor will see that contract later on, and if they don't understand it or not immediately, this might raise already a flag. Okay, how complicated is this investment case? Yeah. So you can already at a very early stage, make sure that your case is maybe more suitable for later investments, including investment in IP activities. Yeah? Then what we also want to see as investors, but we want to see that you're somehow familiar, and that what are you dealing with? Do you understand the risks and opportunities that are in there? And do you know how to deal with it? That doesn't mean that you have to do the IP work as such, for example, filing the patent, but you might have to know, okay, do we need one? Do we not need one? Is the IP activity that you're considering in line with your business strategy? Yeah? So when you want to go and own a market in a certain region in the world, so what is your IP perspective on that region there? Do you understand that region from an IP perspective too? And then, as you probably also know, like also this organization you're listening to today is doing, there are a lot of offerings worldwide on IP related content and know-how. We have in Europe the IP help desk. We have at most patent offices, including the European Patent Office. We have a lot of sources and information for just general information that you can get familiar with, and it doesn't take a lot of time. And some offices even offer hands-on help to, for example, to conduct a search on trademarks or patents or designs and these kind of things. And if you want to do more, then you might need a professional, like a law firm. And then you might argue, oh, I don't have the funds for it, but you also typically don't have the funds to build up a big production. So in this case, this has to be part of your investment plan. So where do the resources come? Where do the experts come from? And how do you finance all this? Yeah. And just as a final note for this aspect here, trademarks. So if you're not in B2C, so business to customers, where you serve like end products to end customers, especially in the business to business, so where you serve other companies, you might haven't thought about it yet, but trademarks typically rank low. And it goes even this far that investors might say, okay, you might own a little hobby, like having a trademark for your business to business brand. But if you spend like more than $100, and this is a quote, if you spend more than $100 on this trademark for a business to business case, then they might consider you of doing the wrong decisions. Because if someone buys you later, if you do an exit or get a new partner larger partner, they will typically exercise their their own brand and will void yours. So if you have spent too much on your own, they would say, okay, it's just a spend, it's just wasted time and money on your trademark. Of course, if you're building up an own brand, a consumer brand, then you might argue, no, trademark fits my business strategy, so it fits very well. Okay, then further on, I show you an opportunity case. One successful case here I can promote here is Nespresso. So it's a coffee served in capsules. The consumer typically would buy or use a machine that has a comparatively low price, whereas the coffee in the capsules, the so-called consumables, are having a high price. And so the business model works on selling the capsules. And there's even a name to that. You remember Spotify was the name for the business model, was called the freemium business model. And this business model here we call razor and blade. It refers to the shaving razors, where sort of the razor is the consumable and sort of the rest is just for free. So the difficulty with with such a business model, razor and blade, is that, of course, if this becomes successful, then competitors will try to join your success and will try also to sell the consumables, in this case, the coffee capsules. And especially here, it took Nestle or Nespresso almost 10 years to build up this market, because beforehand, nobody knew that they would need coffee capsules, right? So imagine if someone has to invest in the market, invest into the technology. They have spent a lot of budget already on developing the technology in the market, whereas fast followers, sort of competitors, wouldn't have to recover those costs. So they could either sell the capsules at a much lower price, so consumers would run away from you and to the competitors, and you would just be drowned in your own costs from the past. So an important aspect with this razor and blade business models is how can you protect the consumable of not being disrupted by competitors? And Nespresso here understood this very good. So they realized we are using legal rights, including intellectual property rights, to protect I would say, the interface. So the interface, the capsules are brewed in this device here. So to protect the interface. And if you're talking about a business IP strategy, this is sort of the area where the IP protection is important. Whereas, let's say, the switch, the lightning of the switch, maybe a temperature valve or something like that, is, from a technical point, you could maybe also argue maybe we can patent something there too. But for the business model, let's say the temperature valve has not a big effect. The customer even doesn't realize that there might be a temperature valve in that device, right? But what they see is, okay, does my capsule fit in here? Yes or no? Is it brewed? Yes or no? Is the coffee good? Yes or no? These kind of things. So they put a lot of effort, although it's not easy to protect such interface on this interface, and put a lot of IP rights, begin applications on it. And second, they combine sort of the legal part with a factual protection. We call this factual protection in, for example, having a new channel, typically in this case, direct sales, which is also very difficult to build up. So consumer would get the capsules not via the typical retail stores, but via an own club, an own brand, later own shops that Nespresso was running, where you could get those capsules. And then third, which is also important, they were watching about the market. And as soon as competitors were coming up and offering their own capsules that were supposed to be brewed in Nespresso's coffee devices, they would execute the IP rights very consequently. In the end, they managed to build up a large market, increased their turnovers, and they managed to keep competitors so far away that they could build up a strong brand, positioning them in the premium market. And because now you go to a shop and you can buy sort of capsules that will also fit their machines, but they are priced differently, and consumers still go to Nespresso and pay much more because this is sort of how brand management works. And I think this is a very good example. And there's also I find a lot of stuff in literature and in the internet on this case. So far, there is not a movie yet. So I'm waiting for another movie. But you can see that this is from a business and also startup perspective a very important case. And if you're a very small startup and say, well, I wouldn't have the funds to do so, maybe not. But then you have to talk to investors saying, look, if we want to do a razor and blade model, we need to do those IP-related actions. And if we don't, we just don't have to continue. Yeah. So you won't be successful if you can cover this. And this is business model related and sort of business strategy related, and IP strategy accordingly to support the business strategy. Okay, I have a summary for that. You can see this here. So we have the different legal activities. And the good understanding is that those two have to be merged and set to each other. And the way how you merge it and optimize it to each other, it works. And it also says to protect your business model. In this case, it's not only a legal activity, it's also, I've mentioned some here as examples, factual protection strategies. And as an entrepreneur, as a startup, or a head of an SME, it's very good to understand these mechanisms and to optimize them and to use the best strength you can build up to do so. And in the end, it's not the question, it's, oh, I have a patent or not. In the end, is, do I have a good competitive advantage? And can I keep that competitive advantage compared to competitors or uprising competitors, or to established companies that just might say, okay, this is interesting what the startup did, so let's do it ourselves too. And then becomes music into competition, right? This is why we want to be entrepreneurs, to have this, right? Okay. So, and I'm drawing now some conclusions. We did a project a couple of years ago with investors and startups and established companies on how they deal with startups actually, and what role and relevance intellectual property rights would play there. And as you can see here, this is a statement from an investor in the Silicon Valley. They said, like, look, we have like 3 important categories. One is the market, second is the team, and the third is the technology. And there the IP comes in, the intellectual property rights mainly, right? So market, team, and technology. And even in the beginning, where you might say, okay, we don't even know what this IP will be and so on. Here already comes in, if you can show as a team that you have an understanding of working with the IP and understanding when risks would come up, and also when is the right time to rise opportunities, sort of having this basic savviness, then if you can prove this, you're making a much better impression on these investors, and some even make this as an important aspect for the investment decisions. This might, however, of course, depend a little bit from the industry sector you're in or the markets you're trying to tackle, depending on the culture and the nature of these industry sectors, technology sectors, or markets. Okay, and another aspect and a typical also learning curve you can sort of read here is if your IP activity is not related to your business activity, then it basically shows 2 things. One is you're not competent for this understanding, which makes you very bad in the future in terms of I'm getting the best out of it. And second, I mean, recently a colleague told me, well, from a startup, they told me, well, we have filed a patent, and this is all what the investors want to hear. We have a patent. No, and I would say no, that's not enough, because if you just have a patent that doesn't have any benefit for your business, then it's even worse. You have spent money on something that is useless. So the question here would have been, does that patent support anything of your factual activities? Does it support anything of your business? And actually, what does it support? And if you don't understand this, then you're either wasting money, missing opportunities, or just not getting it out of it, right? And second aspect is unclear IP ownership, especially when you get maybe as a spin-off from a university. You might get the large contract from the university, you just sign it because you don't want to deal with it, and then you're sitting there. But the investors will look at this, and what we typically don't like is that these investors, as investors, we don't like if the university stays at the table and not as a co-investor, like owning equity, but as a sort of sink of cash that, for example, wants, based on a licensing contract, royalty incomes based on their IP. So we don't like this. So you can already check this in the very beginning. If the university only offers you a licensing contract, then you will have a worse situation later on when you're looking for investors than compared to you just having equity, for example, for the patent the university was having. Ideally, you even get the patent, if I take a patent now as an example, and can work on that. And the university may would only earn equity as a return. Then in some legislations, like for example, in Germany and in Austria, but also in Switzerland to a certain extent, employ invention rights. So imagine people at the university invent something, the university takes the patent, and even if it gives it to you, but if it's unclear what remaining rights, or what rights do remain compared to this, let's say the professor and their team, then it also might make the contract complex, or might be a risk left over. Do we still have to pay later on any licenses to those inventors, for example? So this is not in soft or students that were working on the project. Were they there as employees or as free students, which, for example, in those legislations would make a big difference, yeah, whether you own the IP or not. Or the owner owns the IP, let's say the patent privately, but the company runs with a sort of maybe even informal license on the patent that the owner is having privately, owning the patent privately. Investors don't like this because it will bring up, as soon as the company becomes successful, or the new investment comes in, then it will make things complicated. Yeah, and to conclude, two more. Try to switch on to the next slide. Doesn't work. Maybe Fernanda can help me. Yes. Okay. Yeah, a summary for SMEs, because it was said we have some SMEs, so small, medium enterprises and startups. You can see for SMEs, the list is already a bit longer and more sophisticated. Again, here, first position, get your IP strategy and your IP positioning aligned with your business strategy. Understand your risks. So that's why we say monitor third-party rights, do your freedom to operate research to that extent that is relevant for your business. Get the right people on board, either in your company or as experts that you steer. Don't let them steer you. You are the principal, and the law firms are the agents. So be the principal and act as a principal, and get things done in the way that you want to have it done. And how can you do this? Just as an example, typically we have this strategic level where we deal with, okay, what type of freedom to action do we need, and deal with the differentiation, meaning you have to, for example, understand where is your business differentiating from others, like think of the Nespresso example. And there I want my IP activities being the best and the most useful and most edgy one. And finally, don't only focus on risk mitigation, but also on opportunity creation. So how can you use IP, for example, to build up your business, support your business, grow faster with your business, and what do you have to do with it? For example, again, Nespresso example, it's not enough to own that IP or to have the patents and trademarks in place and the design rights. You need to enforce them. They needed to enforce them. Otherwise, they would have been useless, without any teeth, as some others would also call it. Then get the right processes in place, the right organization to that. And that can be, you can outsource a lot, but you still need certain processes internally to, yeah, to build up your opinion, to take decisions, ideally informed decisions, not not just the gut-based decisions, informed decisions, and in many cases with certain speed. So like we're used from startups. And then finally implement those things, get it done in time, pragmatic as you are or need to be. And it will need a certain, how we call it, culture and communication to get this done, even if you're a very small team. And it also includes a certain monitoring, performance measurement. For example, cost management is one thing, but only costs. If you just focus on cost, you don't see the value. So you also need to focus on what value you are creating, which is not so complicated if you have already this understanding of aligning your IP strategy to the business strategy, or from a business perspective, saying what type of IP activities do I need to support my business strategy. So to conclude, you see once more the value drivers, especially for startups, market, team, and technology, including correct IP that you need for that. So think of the switch of an espresso machine. For that business model, we don't need necessarily a patented switch or a patented valve. What we need for the business model is the interface, the brewing technology that helps to understand which capsules are my own and which are the ones of the competitors. And typical mistake, especially when we started startups, is unaligned business and IP strategy, as mentioned, unclear ownership, unresolved employee invention rights, and or ongoing obligations that pull cash out of your account. Yeah, and by that I'm finishing with the presentation part, and I think we can move on to questions from the floor. Thank you.
Yes. Thank you so much, Martin, for the presentation. I think it was great. I have taken notes of so many things and also the shows that I have to watch. So that was great. We have received quite a lot of questions. So I'm going to start with the first one. It says, how can startups ensure their IP strategy is aligned with their business strategy to avoid the common mistakes that damage investments?
Yeah, how can they do this? Well, one thing is, first of all, to understand your business model and to know how does it work. So if you're doing a freemium business model, you might have to see, okay, if everything is for free, then the question is, what will be the part where companies are attracted to you on this freemium level, and what is the level why consumers would then start paying for an additional service? And both need to be interesting. So the low barrier, if it's totally crap, people might not use it. So think of the seamless streaming technology that was already part of the at Spotify. That was already part of the freemium offering, but making it very special and saying, look, if you go to Spotify, you have a totally new experience. So it made, from that perspective, makes sense to not offer this technology to everybody, but sort of to try to keep that specific, that people would come to your platform and not to others. On the next level, what would be different? So you need to offer something too. There, we can argue now in the music industry, is it now important to have that? To have there an edge too, competitive edge, and I think in most cases you probably argue yes. So it could also be very important to make sure that this would also be part of a certain protection, factual and or legal. And the important part is that you can make sure that you have it, right? If you think of the Nespresso case, if you look in the details, patent attorneys at that time would have probably argued, oh, it's very difficult to protect the interface, it's two devices, and saying this, they would bring all of legal problems why this wouldn't work. But from a business perspective, it's a bit like very clear. If you cannot factually and or legally protect this interface, protect that your capsules will be sold, at least for a while, then you're basically dead before you have begun, because you will never recover your sunk costs, because competitors will be below your price value and eroding you very aggressively.
Yeah.
And in a discussion with an investor, it would be, I mean, of course, you need to find an investor who understands your business model, but typically they do. And then they like you, especially if you understand and explain your business model, because they say, okay, if we make this happen, including the IP, legal and factual work, then this will be a big success. And they will also understand that to do so, we need a certain budget to realize it. So a legal budget is, you see, it's not an abstract size to say we need like 10% for the legal budget. It's more like, okay, in this case, we need to really invest in the factual and legal protection. Otherwise, the business model won't work. And then you put a value to it. And then you can say to create that value and defend that value, we need a certain amount of activities. And then you can sort of price it, round it up, and then say, okay, we need this amount of the investment. Otherwise, the investment is void anyways.
Yeah, it makes sense. And actually, our next question is a little bit related with this, with the investment. So it says, startups often don't see short-term financial gains in investing in IP versus other investments with clearer and more direct impact on transactions and cash flow. Could you please comment?
Yeah. I think you see who is investing in your startup. Of course, you as a founder, your founding team. If you don't see the use of any IP in the future, there might be two reasons for that. One is you don't know the area, so you're basically ignoring it. Then it would be an uninformed decision to do something or not. And if you tackling it and saying, look, we need certain activities done, we need certain IP in place to protect our business model or to create certain opportunities. It's a bit like you're going into production. When we start production or prototyping, we also say, well, we need a prototype or demonstrator, so we need a certain budget to create it. Time, resources, including financial resources. And then it's very natural that we say, okay, we need a budget for this. So if you talk to an investor, we would argue about this budget. And it's exactly, my argumentation is exactly the same for the IP part. So if you know that this IP activities are important to align it with your business idea and to protect it and support it, then put it like a second statement into your investment plan, like a second chapter into the investment plan. And look, we will want to do those activities to do this and this, and then you can talk to the investor. And if the investor doesn't understand it at all, you might have to redo it again. Maybe you have under or overestimated certain aspects, but it might also be that a certain investor is not understanding the case, and then they might be not the best investor for you, and then go to a different investor who will understand it.
Okay, yeah, that makes sense. The next question says, for a startup trying to protect its tech, especially compared to Spotify's approach, what's the best way to ensure patents and other IP rights really help with differentiation?
Yeah, I also tried to mention this, especially Spotify. So you could see they had protected some of their technology, like the seamless streaming technology. But it wasn't like, oh, we have an invention, so let's try to file a patent on it. It's a clear understanding that this technology is an important part of the experience for consumers that will make them reference or give positive references to the platform technology of Spotify, and would make people move from maybe less developed other platforms or other illegal platforms to Spotify. And then the patent makes sense because competitors cannot easily create the same experience like on your platform, and that makes it attractive for people to try it. And if you get the consumers on your platform, you have already won half of the race. Yeah, as we say.
Okay. Okay, the next question says, Since patent value evaluation is a very expensive service, how can a startup afford it in order to mitigate IP risks before investors come in?
Yeah, this is of course a dilemma
Yeah.
with everything. So we typically say don't buy a big car in the very beginning because investors say you're wasting the money. With IP, it's different. And I think there the important part is to get an understanding about the real priority for your business. You might argue, well, speed is very important in the beginning. Yeah, go for speed. But also understand that there might be certain aspects that you're doing that might not be reversible. So when you, let's say, publish your ideas and inventions and show it to everybody, then it will be impossible or hardly possible to get a patent on that later on.
Yeah.
And if that, imagine with Nespresso, if that was your key technology or the streaming, the seamless experience with Spotify, then you cannot reverse this. And then you sort of lost the edge of your protecting your business model later or generating it in a way as with Google Earth, Art and Com basically missed out. And you as a startup or as a founder have to make this balance. It's not easy. In many cases, it's not easy. But how can you optimize it or take this balanced decision if you don't understand it? So the core is get the understanding and then try to find a solution for it based on the understanding you have and also on your capacity.
Yeah. Yeah, timing is so crucial. So there is a question that keeps coming in. It's a little bit tricky, but let's see if you can give them an answer. It says, how can the value of the IP portfolio be calculated? Which are the best methods?
Okay. I think for you as a startup, probably it's not really in the beginning that you want to calculate the value like an accounting company, right? But what you can do is, for example, you could calculate, take the Nespresso example, how big the erosion of your business will be if you cannot, and not independently of the means you're applying, if you cannot protect it. With the example of Spotify, you could argue, okay, if this streamingless or seamless streaming technology can be used by others, how many users will you not get, or will you get less, or will it take more time for you to get them on your platform? And then you can put like if you take this time or the loss or the additional win, you can put a business value to that. And then you might be able to say, look, the IP activities or the combination of factual and legal protection means here would have a value that is benchmarked at this business level. And then you can say, well, like certain aspects will go to that business value. And then you can put a rough value to that. And that would be typically also the estimation I would do as an investor or investors do to see, okay, does it fit together or not? It's not counting an accounting value that we put in our accounting bill. And if you're doing it in a deal, for example, dealing with a university, then it's a bit a larger picture. Then it's also what alternatives does the university have? If they can't sell it to anybody else, then yeah, if they say, look, I have already someone who will buy it for this value, then this is your benchmark, right?
Okay. Yeah, that makes sense. Okay, so the next question, I'm just gonna go through because we have quite a lot and not so much time left. It says, how can startups best prepare for due diligence from investors, particularly concerning their IP assets?
Yeah, I mean, first of all, is to take it serious. So take it serious and prepare for it. And preparation here can mean, first of all, for example, what activities you have done and maybe also what you haven't done. You will be able to judge on your known risks and maybe unknown risks. You will be able to explain how your IP strategy is really aligned and fits your business strategy, like mentioned with the Nespresso case, like mentioned with a Spotify case. And then, depending on what investment level we are talking about, if the investor sends you in a legal team for the due diligence, you could say, well, if they are your real friend, then they will help you to prepare the data for the due diligence. And if they are just one of the ones who offer you a new investment, you're working with your current investor, then of course you would work with your existing colleagues and your existing investors to prepare it very well. I mean, getting, for example, a law firm in it to prepare it. So you're not fully dependent on the questions from the potential new investor and their law firms coming in. Basically, get the professionals on board and get also budget for doing it.
Yeah, try to get ahead.
Mm-hmm.
I think you're giving great advice. Okay, so the next question says, looking at what happened with Napster, what are the key lessons for startups when it comes to avoiding IP pitfalls?
Yeah, I mean, one thing you could say, play by the rules. I mean, this is official business, play by the rules, because it's very likely it will come back. Don't ignore, and don't think you're safe because you don't know something, like the big birds who put their head in the emus, yeah, who put their head in the ground.
In the ground,
So
yeah.
don't hide away. Tackle it, and typically the earlier you tackle it, the more options you have to create opportunities and to react. If you're waiting like RIM, like Blackberry, I mean, you could argue, well, great, they had enough money, they were so successful that they could continue. Yeah, but if you look, they spent like 5 years on their legal teams. It was annoying. They were in the press up to the White House in the US, and in the end, they had to settle at an incredible high price, historic price, for something that even in the end turned out to be really void. So you could say, well, this is how to spend too much, and you could argue, well, if you'd rather try to do it like Spotify, in time, get things done, get your business model on the legal side, then you were building up a sustainable business. Right?
I think we have time for one more question. Okay, so I will have to choose this one. Besides the usual formal IP protections, are there any informal strategies like lead time advantages that startups can use to stay ahead?
Yeah, I think it's but you see, this might be you might consider this in your normal business activities, but it might be valuable for you to understand actually by which normal business activities do you actually create the edge, create the innovation, and by what kind of activities do you maintain this position. In sports, you would say, how do you become number one? That's one part of the strategy, and the second is how to stay number one. And based on these two business activities, you can then say, look, how can IP activities help me to become number one and to stay number one? And to stay number one might be something you have to do already in the very beginning. So while you're still catching up, you might have to already invest in that activities that help you then later to stay number one. And this is maybe also a bit the dilemma we have, big difference in time. Yeah.
Okay.
That's a challenge. Fair enough.
Okay, great. Well, I'm afraid we are reaching the end of the webinar. We don't have more time, but I wanted to thank you so much, Martin, for all the information you have given. I think it has been so helpful to our audience. So before we go, I just want to remind everyone that the recording of today's webinar, together with the slides, will be uploaded to our website tomorrow, so you will be able to access that. Also, you can already register to our upcoming webinar. It's called Retroactivity in the Proposed SEP Regulation, a Legal Analysis, with Professor Dr. Leigh Hunter. You can either go to the webinar section on our website, or you can scan the code on the screen. And finally, we will send you a very brief survey to ask you how much you like this webinar, and also other topics that you would like us to cover on these webinars. So it would be great if you could answer that. Again, thank you so much, Martin, for your time, for sharing your knowledge and your expertise with us. It's been a pleasure. And I hope you all have a great day.